What's going on? I want to talk about some things. A lot of things I want to talk about is basically going to be very simple because a lot of people, they give a lot of misinformation on the internet. And sometimes people think I'm being condescending, but I got a backhand comment like, I like your information, but you're condescending. I personally don't care about your opinion when it comes down to how I'm conveying the information. Let me tell you why. If I'm humble, people will abuse your humility. If you're arrogant or if you're kind of cocky, then people call you arrogant. So there's really no win. So you might as well just provide the information as you can, because it really I don't. I could just shut down the channel. It's this information doesn't really make me any money. I just try to give it out, give it out and offer consultations to people who need assistance. But we need to get some things that are very clear. And today my fragrance is Guy Mead. This stuff is fire. I already had like 2, 3 compliments on it, and I just wore this one day. So let's go. And I don't even care about compliments. So a lot of times people have to understand. It's a lot of people telling you guys about Cestui Que Trust, etc. How loans are created, and they are completely. A lot of them are incorrect to some degree and to some extent. But we'll go over some of that, and I'm not going to go over all of it, but I'm just going to do a short video, um, and we're going to talk about Cestui Que Trust. And this Cestui Que Trust is, I know people understand the 1666 Act, but there's a lot of misnomer with this Cestui Que Trust. So we'll go over it. So they know about the Cestui Que Trust, even though they try to say it doesn't exist. But people are telling you that your birth certificate is why they create Cestui Que Trust, and that's not correct. It's built. It's really done by contract. Okay, so the legal concepts behind Cestui Que changed a bit over the centuries in order to reduce fraud and to ensure that property owners couldn't shift their property into trust in order to dodge creditors. More recently, laws against property held in perpetuity required that parties named as beneficiaries in the trust should vest and thus have an interest in the trust rather than passively receive benefits. So now, when people tell you that, oh, everybody's pulling off your Cestui Que Trust, wait, did you just hear what that just said? Let me read that again for you, okay? The legal concepts behind Cestui Que changed a bit over the centuries in order to reduce fraud and to ensure that property owners couldn't shift their property into trust in order to dodge creditors. More recently, laws against, now you have to remember when they're saying dodge creditors, this is back when banks used to loan money. This is back when not just banks used to loan money. This is back when entities used to actually loan something. You know what I'm saying? Now they just got out of it and found a way to do futures agreements. Okay. More recently, laws against property held in perpetuity require that parties named as the beneficiaries in a trust should vest and thus have an interest in the trust rather than passively receive benefits. Okay? When a trust is created, it is done for the benefit of a specific individual who is identified in the trust document. So when you get approved for a loan, what do you think is happening? In a trust, the Cestui Trust is the person who has, wait. Did it just say that? See, you're thinking a Cestui trust is created by your name on a birth certificate, and then the birth certificate. No. Your credit profile that they use to create the trust allows them to do this. Okay. It is the trust in and of itself is a person. You see what I'm saying? That's why you have a principal on the account. And for you guys who've talked, we've done conversations, you should already know this stuff. Okay. But I'm just breaking it down because sometimes you have to keep going over things, keep sculpting that clay until it starts to look like a piece of art. In a trust, the Cestui Que Trust is the person who has an equitable interest in the trust. The legal title of the trust, however, is given to the trustee. Who's been bringing this up? Who's been bringing up that this has all been about title? It's been me. All of this stuff that people are telling you on the internet, they're telling you to file all this stuff, file 1099s, all this other stuff. Wait, hold up. If I granted the power to the trustee, can I revoke it? Ooh, did he say that? Yes, he did. Cestui use or he uses is the person for whose benefit the trust is made. Okay? Let's say it again. Cestui use or he who uses is the person for whose benefit the trust is made. If that is not expressed, then the bank can do whatever they want. During the medieval period, Cestui use arrangements became so common that they were often assumed to be present even when they had not been arranged. I keep regurgitating the same stuff over and over, and people just did not keep understand me. I have given you guys the answers to everything. At least 10, I would say probably, I say 20, 30 times. And people will say, I'm piecing it together. I'm not giving you the answer. Man, I done gave you the answer like 50 million times. Look, we'll go in Black's Law Dictionary for people who like to use Black's Law like it's some form, like it's some higher source of information when it really isn't. He who has a right to a beneficial interest in and out of the estate, out of an estate, the legal title to which is vested in another. Okay, look. So the bank is holding legal title over your account. This is why they are billing you in benefit of them. But you're holding equitable title. Until you are holding legal and equitable title, from there you can appoint a trustee. This is the problem that you guys are having because you're not listening to me. I keep saying it over and over and over and over. And then people are like, how do I do this? Research till you find the answer. When you find the answer, you're going to be pissed because I've already given it to you. Okay. The person who possesses the equitable right to property and receives the rents, issues, and profits thereof, the legal estate of which is vested in a trustee. It has been proposed to substitute for this uncouth term the English word beneficiary, and the latter, though still far from universally adopted, has come to be quite frequently used. It is equal in precision to the I can't take antiquated and widely Norman phrase, and far better adapted to genius of our language. Okay, so now we understand what a SESK-VI is. Okay, whenever you're opening up an account and you get approved, you are forming a SESK-VI trust. Did you know that? I know you didn't know that because people are telling you that people are borrowing against your SESK-VI trust. Now go ahead and let me put a cigarette butt out on that real quick. I'm going to put a cigarette butt out on that. Why not? Why not? Look, I asked a simple question and I got a simple answer. So, how is a loan created? Okay, this is what you guys don't understand. The bank is not borrowing you money. You are borrowing money against your own labor. Okay, so borrowing against someone's income typically involves obtaining a loan or credit based on that person's earning potential. What? So they don't go into your Cestui Que Trust and then pull out the money, and they don't go to the Federal Reserve and they don't. No, they are borrowing against your future revenue. That's how you obtain loans. For all you people who are telling people they have unlimited credit, you can't have unlimited credit if you don't have unlimited debit. That's what I'm trying to tell you. There are a few common scenarios where this may happen. Co-signing a loan. Well, did you know you were co-signing a loan? No, you did not. Did you know when you signed for the note that you were loaning the bank money that they can use in perpetuity until the maturity date? No, you didn't. Why? Because you don't read. So I don't care if people get mad. This is why I am teaching you this. Because if you already knew it, you wouldn't be on this channel. So somebody that was very funny that somebody gave me a backhand compliment. I love those backhand compliments. That is funny. Keep them coming. So look, personal loans. Some lenders may offer personal loans based on an individual's income. The borrower's income and credit history are usually considered during the loan approval process. However, the loan is in the name of the individual seeking the loan, not the person whose income is being considered. So, now that we understand this, we understand secured loans, joint loans. Okay? So when you're getting a loan, they are borrowing against your potential earning potential. They're not pulling it out of some Cestui Que Trust. They're not pulling, fam, you can't just create. The only way you can create money is through debt, through transactions. That is the only way to create money. You don't have this account with infinite amount of money sitting in it. People are lying to you. They don't know they're lying to you, but here's how this whole thing goes down. Okay. This is what's called a collateral certificate. So, what I asked was a very simple question. I said, basically, I went through this and I said, they don't loan money, right? Like you guys thinking that a mortgage secures your mortgage is secured by the house. It's not. The mortgage is secured by the collateral certificate. So you have to understand what a collateral certificate is. I will allow you to do your own research. That's why I don't give you all of the answer, because I want you to go on your own diatribe or your own tangent and do your own research. Okay. A collateral certificate is known as a certificate of collateral or a collateral receipt. It is a document that proves evidence of ownership or interest in a specific asset or property that has been pledged as collateral for a loan or a financial transaction. Well, why do you think I keep telling you guys you need to learn how to do a debt validation? What are you seeking when you're doing a debt validation? You're seeking what? Evidence that you have an interest in a loan in a financial transaction. So you're not making a claim. So they make a claim and you get mad. And you're like, what do I do? What do I do? They're giving you the documents to make a claim to, and you're not doing it. Look, I've said this like 5, 6 times. I don't know how many times I can say it. Okay. The certificate serves as proof that the borrower has pledged certain assets as security for the debt, and it outlines the terms and conditions under which the lender may claim or seize the collateral in the event of a default. Well, who's the lender? You are. The bank didn't lend you any money. Why? You didn't receive any money. So if the bank didn't lend you any money, who is the lender? You are. Even if you lend money to even if the bank does send you a check, if you gave them a promissory note in lieu of the check, that means that the books are balanced. The bank's books have to be balanced at the end of every day. Y'all, man, y'all need to learn banking, fam. So what I'm gonna try to do is I'm gonna try to teach more. But sometimes like when people do comments, sometimes the bad comments fuel me. I don't know why. It's the good comments that should be fueling me. But that's human nature. So look, so the purpose, okay, the purpose of a collateral certificate is to document the existence and details of collateral associated with a financial institution, such as a loan or a secured debt. Okay, the contents. The certificate typically includes information about the collateral, such as its description, location, and value. It may specify any conditions or restrictions related to the use or maintenance of the collateral. Pledge agreement. The collateral certificate is often accompanied by a pledge or security agreement that outlines the terms and conditions of the collateral arrangement. This agreement specifies the rights and obligations of both the borrower and the lender. Okay? If your rights are not specified in a collateral agreement, it is what? Invalid. Transferability. Look at all of these are in all of they're in your credit transactions, they're in all of this. So, transferability. In some cases, collateral certificates may be transferable, allowing the lender to assign or transfer its interest in the collateral to another party. Transferability is usually subject to the terms outlined in the agreement. So if the lender can transfer the agreement, and you can't, what do you need to do with that agreement? You need to change and modify the agreement. Enforcement. If a borrower, because they're the borrower, okay, if they receive something without providing service or without providing anything to you, that means that you're the lender and they're the borrower, and you need to correct it. Enforcement. If the borrower fails to meet the terms of the loan agreement, the lender may have the right to enforce the collateral, meaning you. See, they're talking about you. You don't understand because you're not reading and you're not looking at your agreements. So when I'm saying this stuff, I'm not trying to be mean. I'm trying to be honest. It's not like I didn't do this. It's not like I wasn't ignorant. I didn't read stuff. You know what I'm saying? So since I didn't read stuff, it made me liable to stuff that I wasn't liable to because I didn't read it. And then what we think is we're in a debt collection, and no, what you're in is a negotiation. You're not in a debt collection, you're in a negotiation, which could involve seizing and selling the pledged assets to recover the outstanding debt. So that means if they can do it, you can do it too. Legal implications. Collateral certificates must be associated agreements, are legal documents, and their enforceability may be subject to the applicable laws and regulations. It is crucial for both parties to understand and adhere to the terms specified in the certificate and the related agreements. Now, you have to understand when you're dealing with these collateral agreements, right? They are subject to collateral attack. Now, you might say, oh, this has to do with court. No, 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 no. Collateral attack. A collateral attack is also called an indirect attack, is a challenge on the validity of a prior judgment. Okay. Now, look, you can use this in the context of a court, but you can do a collateral attack towards any outstanding obligation. Just because it's required in court doesn't mean it can't be done outside of court. Okay. So we're going to go back to how the lender gives you this alleged loan, which is you're loaning the lender money and the lender is not crediting you. Okay. So look, I asked a simple question. I got a simple answer. Yes, that's correct. When a bank or lender provides a loan secured by a house, car, or another valuable asset like an access device, huh? thinking about a credit card, they typically use a collateral certificate as evidence of the borrower's pledge of that specific collateral. So this is why I tell you stuff like I don't look into the FDCPA, because the FDCPA is created for what? Interstate commerce. So people, consumer law. And I'm like, it's contract law. You know what I'm saying? Every contract is everything, or agreements are everything. Whatever you're deemed as agreement, it could be an implied agreement. So I'm not going against people who have consumer law. Keep chasing your statutes instead of seeing what the crux of the issue is, which is the actual agreement. The collateral certificate is a document that outlines the details of the collateral and serves as proof of the borrower's commitment to use that particular asset as a security for the loan. Well, where's my money? Where's my money? I didn't receive it. It's my money and I want it now. In the case of a mortgage, for a house or an auto loan for a car, the lender will have a security interest in the property or vehicle. So now you see these goofs on the internet telling you that an MCO gives title when you are not a party to the MCO. You use the MCO to prove that the bank doesn't have title. You cannot sell a car you do not own. You cannot sell a house you do not own. If you do not own it and you try to sell it, that means that there could be issues with title. Mm. The collateral certificate, along with the corresponding pledge or security agreement, specifies the terms and conditions under which the lender can take possession of, meaning you, sell, meaning you, or otherwise enforce its interest in the collateral if the borrower, meaning them, defaults on the loan. You gave them a loan. They didn't give you a loan. What, fam? If you walk into a bank and then the bank cuts a check, you sign a promissory note. That means the books are even. The bank gave a check and they issued a check that was backed by a bank based on the promissory note you signed. This is not people telling you all this stuff. All the bank does is you give them a note. They take the note and they can deposit it in their account, or they can create an account on behalf of you and deposit it in that account and then issue a check from that account. Why? Because you don't understand. When you understand all of the stuff that I'm saying, regardless of my tone, you can't get rid of the truth, regardless of how it sounds, because I'm giving you the truth. It's not all of this. They do not pull from your social security account. They don't do all of this stuff. Why? There is no proof of that. If there was proof of that, that would be a violation of the law. What they do is they use your information and then they conduct business in your name. Why? Because you don't conduct it properly. It is important to note that the actual process of claiming the collateral may involve legal proceedings, and lenders must adhere to the applicable laws and regulations governing secure transactions. Isn't that something you should learn? Well, let's look up the laws and the regulations governing secure transactions. Let's do that. The collateral certificate, along with the associated legal documents, provide the framework for these actions. In summary, the bank doesn't securitize the house or car in the sense of bundling it with other assets or other assets to create securities for sale on the financial markets. Instead, they use the collateral certificates and associated legal agreements to establish a security interest in the specific property or asset that the borrower has pledged as collateral for the loan. Who said that? Me. I said that. Why did I say that? Your loan is an unsecured loan, and you're sitting here under the belief that it is a secured loan, and it is not. It is 100% not a secured loan. Why are they able to enforce a repossession? Why is the bank able to foreclose on your home? Because the bank is operating under the presumption that there is an agreement for them to do this. Why? Because you never read your agreement. And with that being said, I'm not even going to look at the laws of government because I already gave enough dope information on this. With that being said, I wish everybody a good Saturnalia and all that other good stuff. If I don't do another video before then, no, I'm just playing. I'm not even into that stuff, but that's basically what it's based off of. But you know what? I wish everybody a good time and good day or whatever that good stuff is. I'm out. This is